Good afternoon, ladies and gentlemen. It's good to see all of you right here for the lunchtime panel. You'll be enthralled by this discussion, I'm sure. Now, I would like to mention that this session is conducted in English, and for those of you who require simultaneous interpretation in any of the UN official languages, you can collect the headsets at the counter outside of the ballroom. As mentioned at the very beginning of the day, for English is Channel 1, Arabic Channel 2, Chinese 3, French Channel 4, Russian 5, and Spanish Channel 6. Now, we'd like to introduce our panelists right here on stage. I take pleasure, firstly, in talking about our moderator. She is Ms. Corinne Montanari, Senior Legal Officer, UNCITRAL, Secretariat, United Nations. Ms. Montanari was the Secretary of the UNCITRAL Working Group 2 on dispute settlement from 2009 to this year, 2019. She played an instrumental role in supporting the negotiations that led to the Singapore Convention on Mediation. Ms. Montanari's work at the UNCITRAL Secretariat includes law reform in the fields of arbitration and mediation. Presently, she is the Secretary of the UNCITRAL Working Group 3 on Investor-State Dispute Settlement Reform. Ladies and gentlemen, let's give a round of applause for Ms. Montanari, our moderator for the day. Now, as she makes her way up, I'll introduce to you the rest of our panelists. We have Mr. Itai Apter, Director, International Civil Affairs, Office of the Deputy Attorney General, International Law, Ministry of Justice, Israel. Let's welcome him with a round of applause, ladies and gentlemen. Mr. Hector Flores Sentiez, partner Abascal Flores y Segovia. Let's give him a round of applause as well. And Professor Jamin Lee, Professor of International Law, School of Law, Seoul National University. We also have with us Legal and Policy Officer, Directorate General for Justice and Consumers, European Commission, Dr. Norrell Rosner. And completing our illustrious panel, ladies and gentlemen, former Attorney, Office of the Legal Advisor, United States Department of State, Mr. Tim Schnabel. As you enjoy your lunch, I will now hand over the floor to Ms. Montanari. Enjoy this discussion.
Thank you very much for the kind introduction. I will stand just now for the introductory remarks, and then we will all be like sitting like you, but not eating. I think we have witnessed this morning an amazing signing ceremony. 46 states joining a conference. When it opens for signature, that's not so usual. So it's a great achievement, and it shows that states give importance to multilateralism and also to peaceful means for solving disputes. So now we are going to bring you in this panel a little bit backward in time, because we are going to focus on the negotiation of the convention, how this convention came to life, how it was negotiated. And I am surrounded here on the stage by eminent members of delegations who took an active part in the negotiation of the instruments. I know there are other delegates also who took an active part in the negotiations in this room, and so we will be happy to open the floor for remarks, comments, also to the floor later on. So we will keep our remarks short so that we can have interactive discussions with all of you. I think you all know that this convention was prepared by UNCITRAL, and this UN Commission on International Trade Law is one of the commission of the General Assembly of the United Nations. And so, as such, its sessions are attended by state delegations and by international organizations. And for the preparation of this Singapore Convention, we had 90 state delegations who took part in the negotiations, and we also had more than 40 international organizations. This is also high numbers for the preparation of this convention. This convention was prepared, finalized by UNCITRAL, And it was adopted by the General Assembly of the United Nations, which acted as a conference of plenipotentiaries on 20 December last year. So you know there are important dates in the life of this convention already. We had this 20 December last year. We had this very special day today where history is being made. And there will be another date in the future when the convention will enter into force. There was obviously another date which was very important, and it was sometimes in the summer in 2014 when a proposal was presented to UNCITRAL by a state, the United States of America. A proposal was made and presented by Tim Schnabel, who was leading the US delegation and was also a lead author of that proposal, that UNCITRAL should start preparing a convention for the enforcement of settlement agreements resulting from mediation. And the proposal was that that was a piece missing in the dispute settlement landscape. And I will now give the floor to Tim, who is going to give you some lights on what it takes to present a proposal to UNCITRAL and to make it a lively instrument. Thank you.
Thank you, Corinne. It's truly a privilege to be here today and to be on this panel with so many people who have turned into such good friends over the last few years of work. I want to thank the government of Singapore, not just for the wonderful events today and this week, but for their even larger contributions to the convention over the past few years. I can only imagine how much outreach they've done over the past year to raise awareness of the convention. But in particular, I think it's worth noting that none of us would be gathered here today if it weren't for Singapore's contributions during the negotiations. Most notably, as was mentioned earlier this morning, Natalie Morris Sharma from the Ministry of Law served as our chair. I don't think she's here right now, so I can embarrass her a bit in her absence. But as it was mentioned, I mean, she was our chair. It was only due to her masterful leadership of the working group that we were able to accomplish what we did. She was easily the best chair I've worked with in any multilateral forum. And it was our collective appreciation of the work that she did that led delegations to suggest that it should be the Singapore Convention. So again, just wanted to mention her contributions again on this historic day. Now, I was asked to address how the project emerged and why the US proposed it in UNCITRAL. So I want to address those two aspects a bit separately. First, why proposing a mediation convention sounded like a good idea, and second, why UNCITRAL seemed to be the right forum. In terms of why we decided to propose a mediation convention, the path to the proposal was paved with a lot of stakeholder consultations, mostly in three groups. First, we got a lot of input from academia. I think Stacey Strong is here today. She presented a really useful paper at the outset of the process at an advisory committee meeting that we held, and some great empirical research later on. So the input from academia was important. Second, we talked to a lot of mediators. One of the things they underscored was the need to protect the practice of mediation as it existed, such that if a convention went forward, the first rule needed to be to do no harm to the practice of mediation. And third, crucially, there was a lot of feedback from the private sector, from businesses, individual businesses, from trade associations, who told us that a convention would be helpful to them. It was their explanations of a need for a convention, especially from in-house counsel, that really led to our decision to propose the project. So the need that we saw for a convention wasn't based primarily on the existence of lots of cases in which a mediated settlement was unable to be enforced across borders when one of the parties failed to comply. I mean, we did hear some stories like that, and the convention should be very useful for addressing those situations. But primarily the motivation was to help companies who were having a hard time persuading their partners to engage in mediation in the first place. Those were the voices that, from our perspective, made the proposal seem worthwhile. In some states, the commercial sector already sees mediation as a widely accepted option for resolving disputes, as we heard this morning, it being faster, less expensive than arbitration or litigation, but critically preserving those business relationships, coming up with creative solutions that you wouldn't get from a court or from arbitration. But in other states, we were told that the legal culture didn't yet see mediation as really being a co-equal dispute resolution option in the commercial sector. That companies who believe in the value of mediation told us that their partners in some countries were reluctant to engage in mediation. They might not see it as worthwhile, particularly if, for example, there's a contract dispute, and even a successful mediation would just result in another contract that, if there's a problem, would have to be enforced through a lengthy contract litigation process that can be very long and challenging in some states. So the main goal of proposing the convention was to seek to change that dynamic and help overcome some of the reluctance to use mediation, to establish an incentive structure, to shape companies' expectations, not only in the cases where a court would end up applying the convention to give effect to a mediated settlement, but the far greater number of disputes where it will never get to that point, but where mediation would be useful. If companies would know that a mediated settlement would be given effect quickly and efficiently if the need ever arose, then engaging in mediation in the first place would be seen as more worthwhile, and it would be easier for those companies to persuade their partners to use mediation. And the hope was that would lead to the use of mediation in a far greater number of disputes that would never end up in court, because so many mediations are successful, and in so many cases, the parties do comply with their settlements. So most of the cases where the convention will be important aren't cases where the text of the convention will ever have to be applied. And we knew that going in from our consultations, but it did make it a more challenging idea to propose at the UN, because it's a more complex argument than just saying X number of mediated settlements aren't being enforced across borders. So we were proposing essentially a convention on the basis that it was needed even where it wouldn't actually apply, by changing the underlying expectations. Which brings me to the other half of the question, is why UNCITRAL? Why propose it there? And a big part of the calculus is that although the New York Convention predated UNCITRAL has essentially been the custodian of the convention in recent decades. And by bringing the project to UNCITRAL, the New York Convention was the natural model, not only in terms of the simplicity of the text. If it had been in a different organization, but the template might have been not nearly as simple and elegant, but in terms of the expectations of states and companies. Everyone knows about the New York Convention. So by holding that up as the model and saying we want a New York Convention for mediation, we thought everyone would understand quickly what we were trying to accomplish. And it would be seen that the international community is making a point of saying that mediation really is a co-equal option for dispute resolution. And since the New York Convention has led to so much growth in the use of arbitration in the last 6 decades, because of that reassurance it provides about the use of arbitral awards across borders. And we frequently, during the negotiations, used the New York Convention as an example for particular issues. I mean, to be sure, we also got creative and broke with the precedent and found new ways of addressing some of the problems that went beyond what the New York Convention did. But the baseline goal remained to develop a convention that would do for mediation what the New York Convention did for arbitration, and make it easier for companies to see mediation as a real option for resolving cross-border disputes. At least that was the goal in making the proposal, and I think thus far, as we saw this morning, things are progressing extremely well. But what we've done is plant a seed, and I think we'll need to wait a few years to see whether the seed does grow into the large tree that we're all hoping for.
Thank you very much, Tim. Thank you for showing how much consultations and collaborative efforts it takes to bring a topic to an international organization. So a state in itself, or a group of states, when they have a project, it comes from consultation they had. And then when it is brought to an international organization, the organization itself will consult. There will be consultations with many states and many stakeholders. And this is not necessarily always seen, but this process has been working and working well, and it is very comforting to see you all also today, because we are more reform to come on the agenda of UNCITRAL, and very meaningful reform. So we will need all of you to continue to bear with us and participate in this process, because this process in the international organizations, this is done for the peoples. So now we are going to turn to Norel Rosner. He was leading the delegation of the European Union and had a very difficult task to not only negotiate with other delegations in the room, but also to hold this legendary 8:30 in the morning coordination meetings with all EU member states. And so Norel, maybe you can give us more information about what it takes for regional organization like the EU to take part to this process.
Thank you very much, Corinne. Good afternoon, everyone, and I hope you all enjoy your meals. And I hope that I hope that we're just contributing to this, to you being able to enjoy your meals. First of all, let me just start by also thanking on my behalf, the government of Singapore and UNCITRAL for the kind invitation to this event, to express my appreciation for the fantastic way in which this event is being organized. I would also like to thank the UNCITRAL Secretariat for the work done in this project, which was very important for the success of this project. And particularly, again, she's not here, but we have to mention her, Natalie Mori Sharma, who did an extraordinary job as the chair of this working group. Now, negotiating the Singapore Convention and the parallel model law on behalf of the EU was indeed a complex process. That process had basically, from our perspective, two aspects: a procedural one, and like everything in law, a procedural one and a substantive one. And I think the procedural one would be indeed a bit more, the more anecdotal one, just like Corinne mentioned. We would start our day about 1 hour, 1 hour and a half, sometimes 2 hours earlier than everybody else in meetings in which we would discuss the topics for the day. In the EU slang, that's called coordination meetings. So we were quite well coordinated throughout this process. Sometimes we had twice these meetings daily, also during lunch break sometimes, and in the midst of the negotiations, and I think maybe the next speakers would speak here about the breakthrough session, the famous compromise agreement session of February 2017. I think there we also had a meeting during the afternoon session. And here again, I'd like to thank Natalie for keeping up with us and basically allowing us this space that was needed, and also to the other delegates that basically they had patience with the EU being in need for time to coordinate their positions. Now, on the substantive side, I would just say that we came a long way in this process. And indeed, at the beginning, and certainly in the first sessions, we expressed the preference for soft law instruments. So a model law was something that, from our perspective, would have been more appropriate. But as part of the negotiations and as part of the compromise, we were able to agree to having both a convention and a model law in order to address different levels of development with the mediation. provided that indeed a number of important elements would make their way into these instruments. And we, on this side of the table, I think we all know what they were, but I think it's important from our perspective to mention a number of them that made their way into these two instruments and are there, and I think they were actually mentioned earlier today as well. So one of them is, as a policy objective, not to have overlap or gap with other international instruments. And we're glad to see that this policy objective was shared by the working group, and this is translated now in the Convention in Article 1.3, which means that you have, for court settlements, you have either the choice of court convention from The Hague applicable, or the newly adopted Judgments Convention, by the way, adopted on 2nd of July of this year, indeed completing this framework of international litigation. Whereas for consent arbitral awards, you have the New York Convention applicable. And so this convention would be applicable for those settlement agreements that would not fall under any of these categories. Some would call them private settlement agreements. Another important point which made its way into the convention was to make sure that there would be impartiality and independence of the mediator and of the mediation process. This is now reflected in, I think, a provision that for which we spent a great deal of time in Article 5.1, letters E and F. And finally, keeping up with the principle of party autonomy, there is a possibility for the states signing and ratifying this convention to enter into a declaration whereby those states would apply the convention only where the parties to the settlement agreement have agreed to the application of this instrument, what we call an opt-in for the parties provision. And that's in Article 8. And I think with all this, I think the convention and the model law, they both have I think a good framework for application. Like it was mentioned in the previous panel, there is no risk of competition because now you have three very clear paths and instruments that would cover each of these paths for litigation, for court litigation that is, for arbitration, and for commercial dispute settlement. I would like to just end this brief intervention with a personal note on this. For me personally, this was a unique and very enriching experience. All the more that throughout this process, I gained some friends. And this is something that will, of course, remain. Thank you very much.
Thank you very much, Noran. It's true that we have seen the emergence of these regional organizations over the past decades becoming stronger and stronger, and that we heard this morning about the need for consistency between the regional efforts and international efforts is really key. So the EU could take a very active part in the negotiations. When there are agreements negotiated on a regional scale, it's very important to keep in mind whatever instruments have been developed internationally, so we can create a more harmonious world. I'm going to turn now to two members of delegations who have made very important substantive contributions also to these negotiations. So we will hear from Hector Flores Santiez, who was leading the delegation of Mexico, and Professor Jae-min Lee from the delegation of the Republic of Korea. And so the floor is yours, and now we are going to dig a little bit more in the substance of the convention itself. The floor is yours. Thank you.
Thank you, Corinne, for this presentation. I would also like to thank the organizers of this event and everyone who was involved in making this convention a reality. It's truly an honor to be sharing this panel with all of you. Before referring to some of the key issues of the convention, I would like to draw the attention to two apparently contradictory principles, which were, in my view, in the back of our heads throughout the discussions in the working group. And we should bear in mind that it is in an international convention we drafted. And the object of this convention is alternative dispute resolution in the commercial arena. And what that means is that, on the one hand, we need to address effectively what the practitioners actually need, because otherwise the fate of this convention would be to remain in a shelf and not fulfill its real purpose. But at the same time, we have to be very careful to also address some policy issues and real concerns from the states that were taking part on these negotiations. Because otherwise we would not have had the result we just saw earlier this morning. So this constant effort in trying to find a balance between these two principles probably explain or partially explain the way in which this convention is drafted. And to explain this, I will refer to at least three aspects of the convention. One is scope of application. Two is the paramount provision that truly, in my view, provides uniformity or potentially provides uniformity. And finally, a word regarding the defenses regime of the convention. On the first issue, well, as you know, not all settlement agreements are actually covered by this convention. This convention refers to mediated international commercial settlements. And regardless of the reasons behind this or the implications that this decision has, in my view, this clearly remains, this is a consistent result with what was proposed by the United States delegation at the beginning of the works, which was in part to foster, to increase the use of mediation in particular. And also to what UNCITRAL ultimately set out to do from the beginning, which was to fill in this void detected by some practitioners on the international settlements not having a very clear or uniform approach in the enforcement stage. So from this standpoint, the convention remained true to its origin. We do have to bear in mind, however, a couple of, I want to call them hidden defenses within the convention, because if we are dealing with international commercial mediated settlements, well, this actually means under the convention that the claimant needs to prove, which is not a difficult thing to do based on how the convention is drafted, but the claimant needs to prove that a mediation actually took place. So this is a necessary step. And the respondent, on the other hand, can use not only Article 5, dealing with the defenses of the convention or the official defenses of the convention, but can actually show as well that a settlement is not actually international or is not actually commercial, or rather that it falls within some of the exclusions provided in the convention. So this is something we all have to be very aware, especially when this comes to practice and the courts are in the need to interpret this convention. Passing on to the second subject, well, this is actually related to the scope of application. We should also bear in mind what the convention doesn't say, what is not written in the convention, which is equally important than what we actually see in the text, because I'm going to put three examples. One is that the convention is not excluding a specific type of mediation. And that means there were some proposals, understandable proposals, in which they intended to shorten or to make the scope of the convention more narrow in order to refer only to structured mediations, probably institutional mediations or formal mediations. But at the end of the day, the working group decided that we should privilege party autonomy and the flexible nature of mediation. So the convention does not make a prejudgment on what kind of procedure was the one responsible for getting to the settlement agreement, which is an important feature of the convention. A second example of this is that the convention is not limited to what kind of to any kind of relief sought under the settlement agreement, because there was also a proposal to limit the convention to monetary relief only, which would probably undermine the richfulness and the complexity that one finds in a mediated solution, which is one of the main features of mediation. And finally, a third example, and the most important one in my view, is that the convention is not providing for a pre-enforcement stage in which the parties need to undertake a procedure in order to gain access to the enforcement stage. One doesn't have to go to a notary public, one doesn't need to certify anything really. So the convention, what it achieves, it's in Article 5, and in my view, it's also the paramount provision of the convention and the true source of uniformity here, because the settlement agreements are going to be able to be enforced for what they are, which is private contracts, really. And this is a very important provision, and it's not a minor one. The working group acknowledged that otherwise the goal of uniformity would probably not be achieved, and it would be hardly an improvement or a substantive improvement on what the status quo is right now. And I will finally, well, regarding that provision, actually, Article 5, it's also important to note that the working group decided to depart from what the New York Convention did by using the words recognition and enforcement of arbitral awards. Recognition is a word full of legal meaning, so the delegates decided to use a more descriptive language and to leave it clear that the parties, there are two things that can do with a settlement agreement. The settlement agreement can be used for a proactive enforcement of what the parties agreed, but it can also be brought up before a court as a defense against a claim that somehow relates to what was resolved in the settlement agreement. And finally, a very brief note on the defenses regime. The defenses regime necessarily has to be an answer to the type of instrument that is being enforced under the convention. We are not enforcing something akin to an arbitral award, neither to a court judgment. We're enforcing a private contract. And what that means is that there are some defenses that need to be addressed that we don't find in an arbitral award or in a court judgment. For instance, one has to take into consideration cases in which an obligation has already been performed, or that an obligation that has not been complied with really conditions the enforcement that is being sought under the convention, or that the obligations were modified, etc. And finally, one final remark. Norel mentioned the importance of independence and impartiality of the mediator, and this was a very important point in the discussion. And when we talk about the enforcement stage of the agreement, what the working group also realized is that the procedure, the principles governing the mediation, and even the conduct by the mediator is not that important at the end. What we're enforcing is the will of the parties. So the convention really links these requirements to the necessary proof that the conduct of the mediation, that whatever the mediator did not disclose or did during the mediation had actually an impact on the consent to be bound by the settlement agreement. Because at the end of the day, as I said, it is the parties who decided to resolve that dispute. This is, for now, all my remarks. Thank you.
Thank you very much.
Thank you, Corinne. So first of all, I'd like to thank the government of Singapore and UNCITRAL for organizing this event. And I'm greatly privileged on this panel to talk about the Singapore Convention. It's a really pleasant surprise to see as many as 46 states signing this convention earlier this morning. It's much higher than we ever expected during our sessions, past 6 sessions at UNCITRAL. So it's a really great surprise, pleasant surprise that we have reached this point at this crucial juncture. Well, I think the fact that we have completed this negotiation, very tough negotiation, just in 3 years, that fact alone explains the demands from the market. So at first, I think there were questions, comments, maybe some chaos in the beginning stage of the discussion, but as discussions went on, it was clear, I think, to many delegations that market demands this type of dispute settlement mechanism, and businesses demand enforceability mechanism globally. So once that consensus is confirmed, after which then the discussion was moving along very smoothly. So I think this is a great effort of UNCITRAL and everybody here to respond to the demand from the market and businesses and industries in finding a way to solving disputes amicably. So as we have already discussed so far, there's a litigation and there's a arbitration, and now we have a mediation part here. So we have a tripartite system: litigation, mediation, and arbitration. So as they say, maybe the three-pillar system is the most stable, most civilizing structure to sustain a system. So in that respect, perhaps the Singapore Convention on Mediation is very important in many respects. Let me briefly follow what Hector just mentioned. I think the biggest success of Singapore Convention is the fact that we try to find very delicate balance in the text. It's a balance between different legal systems globally. It's a balance between disputing parties of a settlement agreement, and also it's a balance between the enforcing court and enforcing court's state and the other signatory, other contracting parties. So we try to find some very delicate balance in the text. So if you have time after lunch, if you could read perhaps some of the articles, perhaps Article 1 through Article 5, you can find some delicate balance. I think that balance is very important in implementing this convention for the future, and also it gives some reliable platform for us to implement this convention successfully. In particular, if you look at Article 5, which is about the defense, the elements of defense and components of defense are very explicitly and in a detailed fashion laid out, so that those elements and components will be interpreted and applied in a very reliable manner for the future. So in that respect, I think the balance of the system and the balance of disputing parties and balance of the different views of enforcement has been well reflected in this convention. And that said, this convention is also important for mediation generally. Of course, this convention is only for commercial mediation settling commercial disputes. But at the same time, this particular outcome and achievement here is also representative of what we can do in settling disputes through mediation. Disputes such as state-to-state dispute and perhaps investment state arbitration. So I think the spirit and mechanism of Singapore Convention could equally apply with equal force to other systems of settling disputes between states and perhaps investment arbitration as well. So in that respect, I think this Singapore Convention is an important stride forward in formulating the future of disputed settlement system in the world. And at the same time, this also shows the important contribution of UNCITRAL's effort, UNCITRAL's secretariat, and how the UNCITRAL is well suited for dealing with this type of system. As Corinne has already mentioned, UNCITRAL is now busy with handling other types of disputed settlement mechanism, ISDS reform as well. So perhaps the spirit of international cooperation and again, the most importantly, the spirit of finding right balance in reflecting different views and interests of many different entities, that spirit will probably work well for the negotiation of other types of projects under UNCITRAL's purview as well. So this Singapore Convention bodes well for the future discussion of similar projects in the global community. Finally, let me also bring your attention to a peculiar system of two-track approach. So we have adopted convention on the one hand. We have also adopted model law, amended model law on the other hand. That's also an effort to find a way to bring on everyone on the same page. So that type of two-track system will probably work for other projects and other discussions as well. So that's also something that we can look into for other projects as well. So all in all, this is an important first day of Singapore Convention, and hopefully many states can join Singapore Convention sometime soon, and more hopefully it can be brought into effect very soon for the implementation of the convention, again, most notably, to respond to the demand, growing demand of the businesses and industries. So we'll see. Let me stop here. Thank you.
Thank you very much. Now we will turn to Itai Apter, whom we kept for the dessert. He's our sweet delegate from Israel, and he's the man who was bridging gaps quite often during the negotiation. Itai, you have the difficult task to make your address in a short period of time because time is running, and we want to hear definitely from the audience. Thank you, Itai.
Thank you. So first of all, I'd like to join others in thanking Singapore and UNCITRAL for the organization. Maybe I'll use the short time that I have to make a few points. The first point, which I think is the most important one, is that we are now here with 46 states signing. And because we are sharing experiences over lunch, I can share with you that after the first meeting, I went back home to Jerusalem and I was very depressed. And I told my colleagues, the big boys are fighting again, and we're again not going to have anything. But then thanks to Norel and thanks to Tim and Hector and Jamin and a lot of other people, we really managed to make a difference. And of course, also thanks very much to Natalie Moise Sharma, the chair. And what was not mentioned, that in one of the informal sessions, she bought sandwiches to everyone, and that was a real help. One important aspect when we come to implementing the convention in different countries is to change mindsets. So currently, when you go to resolve an international dispute, usually go to arbitration if you don't want to go to court. Because mediation is always thought, or was always thought of as something that is very domestic and very local. So our challenge as states, and here I'm representing Israel, which signed the convention today, would be to persuade our stakeholders that they should also consider mediation as an option to resolve international dispute. That is one challenge. The second very important challenge that we face is how to change the tendency of litigants or of parties to come and use to turn their mediated settlement into a court judgment, which is now the practice. Because if they do that, then the convention would not be relevant. So that is another challenge. And the third challenge, which I think was already discussed, is how, but from a different perspective, is now we have 4 conventions. We have the Singapore Convention, we have the New York Convention, we have the Choice of Court Convention from 2005, and then we have the very recently adopted Judgment Convention in The Hague. And the challenge for a state would be how would all these work in tandem in its own legislation. And for us, that will be a challenge to see how it all would work out. And hopefully, if everybody here in the room representing states or coming from states would be party to all those 4 instruments, we can truly have a global system about a rule of law in peaceful resolution of disputes. And if we reach that goal, then we have made, I think we've made the world a little, a better place, at least in respect of resolving commercial disputes. And if that's the only thing that we got from working so hard on this, I think we really made something important. Thank you.
Thank you very much, Itai, and thank you very much to all the members of this panel. As you know, I am from the Secretariat of UNCITRAL, but I've not been working alone, of course, on this project in the Secretariat. I have two colleagues I would like to mention who've done a lot of contributions. Jay Songli, who is not in this room at the moment because he's busy in another meeting, and also my colleague Judith Knipper. I will ask Judith to say a few words because Judith is now going to be the mediation person at the UNCITRAL Secretariat. So for any question, you can just contact her. Judith, do you want to say a few words? Maybe you can stand and they will bring a microphone for you in a minute. Yes, they bring it to you.
Yes, good morning. There's just one point I wanted to highlight because we were speaking about the convention. Mr. Lee invited everyone to read the convention. So if you read the convention, you might also wish to read the travaux préparatoires, and you find them on our website, article by article. I think it's a very easy approach, and you find all the information, all the discussion, including audio recording, so that you would be able to really follow and get deeper into what was just discussed now. The second point I wanted to mention, the model law that was updated at the same time was already mentioned, the model law on international commercial mediation and settlement agreements resulting from mediation, long title. And this is a text that might help in the implementation of the convention, because as of tomorrow we have to start on the different ratification processes and on the implementation of the convention. So it's not the end of something, but it's the beginning of something today. The Secretariat is working on the guide to enactment to this model law, which should be available for the next Commission session. And there are two other texts that are currently under consideration by states, and this is the update of the conciliation rules. The Secretariat drafted the new mediation rules, as they are called now, and their states have time now to provide their comments, and again, hopefully at the next Commission session, we will be able to adopt the mediation rules that would supplement the framework. And the last text, so we have a lot of mediation texts, as you can see, are the mediation notes that are also under consideration by states now and will also be discussed at the next Commission session. Thank you.
Thank you very much, Judith. I see we have a question in the table here, so we'll take 3 or 4 questions or interventions, and so just introduce yourself, and then we'll ask.
I'm Shreyas Jayasimha from India. I also want to congratulate you on my capacity as coordinator for UNCITRAL's National Coordination Committee in India. So from UNCCI, many congratulations. My question is to the panel on reservations. Article 8 of the convention speaks of 2 reservations that states can make. It was not clear from today's ceremony if any states have resorted to seeking a reservation, so I wanted to know if you had information to share. And my second question is to those panelists on the left who spoke about investor-state disputes and state-to-state disputes. As a counsel for a state in investor-state disputes for a while, I see great relevance of mediation to reduce the scope of the dispute, if not making it go entirely. And I'd be very keen to know how the reservations play out in the context of investor-state and state-to-state disputes. Thank you.
Thank you very much. I see other requests from the floor, just behind. Yes.
Good day, congratulations. Sofit Kemaladze from Georgia. So you've mentioned that the need for the convention was driven by the idea that it would help to persuade the companies to use mediation more. And obviously, I mean, the impact will be then that it will help enforce the settlement agreements resulted from mediation. So we're talking about pre-mediation and post-mediation aspects. What do you think will be the impact of the convention on the mediation itself, on the mediation process itself? Thank you.
I got the questions on the back of the room. We've got questions on the back of the room. We will take the two questions, and then we will start answering the two questions.
Thank you very much, Corinne. My name is Jeffrey Chan. I'm from Singapore. Firstly, I'd like to congratulate the working group on the finalization of this convention. I've been following the work of the working group from afar, and I must make mention of underscore the excellent work done by my friend Natalie Morris as the chair of the working group. My question is a very simple one. As has been stated so far, the convention actually has a rather limited application. It applies only for settlement agreements. And settlement agreements are agreements which are firstly international in nature and only agreements which settle a commercial dispute. What is the definition of a commercial dispute?
Thank you very much. And we take a last question. I saw some hands here. Okay, here. We take the questions here on the side.
Thank you very much. A question for the panelists. We saw 46 states sign the convention this morning. Can you shed any light on Europe? Where are we? Why are we so absent? Thank you.
All right, so thank you very much for these questions. I will answer to the first question about the reservations. I think you will have all the information which will be given by the UN treaty sections. What I can share with you now, and it's really subject to any further information, so there may be some additional information that will come later, that at the stage of signature, because there could be reservations at the stage of ratification, but stage of signature, two states have made reservations, the state of Belarus, and we understand that the Islamic Republic of Iran also made reservations. So two states, to our knowledge, so far. I will just allocate the questions, and maybe I will ask Tim if you could reply to this question that we get from the lady from Georgia, asking about the impact of the convention on the mediation procedure.
My own view is that if we did our job correctly, there will be almost no impact. As I mentioned earlier, from our perspective, at least I saw first rule as being do no harm, right? Most people in the negotiations saw mediation as a very valuable tool. That was, it's very useful because of its unique characteristics, the creativity, the consensual nature, and we wanted to make sure that nothing we put in the convention would change the incentives of parties in mediation in a way that would upset that balance and undermine the utility of mediation in the first place. We had long debates about mediations occurring in pubs and whether they should be covered or not, because sometimes that's a really useful setting. And my own view is that, I think we came to the right conclusion in not setting forth rules about the mediation process itself. There's some defenses, some Article 5 issues that can provide a court with the option of not recognizing or enforcing a mediated settlement in a particular situation. But for the most part, hopefully, we will encourage the greater use of mediation as it exists and as it has proven so successful. We didn't want to try to force everyone to mediate in a particular way. Some delegates occasionally said, the first rule of mediation is that there are no rules. And the mediator has to do what is appropriate in a particular case. So at least my hope is that we won't be impacting that much the process itself between, as you said, sort of the lead up to the decision to mediate and the enforcement stage.
Thank you very much. Now, I will turn to Professor Jamie Lee, maybe to address the question of ISDS and how the convention will play in that context.
Sure, thank you. Thank you for the question. My point was that the idea of resolving disputes amicably, that should work even for the states as well. So, for instance, in some recent trade agreements even include mediation part for settling their trade disputes. And likewise, as some of you may know, the investment arbitration as well is trying to find some 1.5 track, which includes mediation or something similar to mediation. So I guess if we have a system of litigation in the investment dispute, and if we have a system of arbitration in the investment dispute, why not having mediation system in the investment dispute so that we can have some tripartite system here as well for investment arbitration? That should, I think, also work for settling state disputes. States are, of course, geared toward binding dispute settlement mechanism, but perhaps states are more favorable sometimes for some sensitive disputes. They will be more favorable toward mediation, to settling their disputes by inviting a third person as opposed to going directly to the very sensitive and legally binding dispute settlement mechanism as well. So that's why I think Singapore Convention's success is meaningful for other international dispute settlement system as well in the long run. Thank you.
Thank you very much. Itai, do you want to say a word about the reservations? You played a very big role in the design of these reservations, and they have an impact also on ISDS, possibly.
Yeah. Thank you. So, yeah, we were in some cases we were termed as, Israel was termed as the reservation delegation, because we saw reservations as an answer to everything, and it was. So, we were right. Concerning the investor state, I can share that this is also a question that came up during our discussions, internal discussions about signing the convention. And we at least saw it in respect of ISDS that Israel will have to make a decision whether it would like to take this reservation or not. And at least in our understanding, if we take this reservation in the future, it means that it would not be possible for us to use the convention for ISDS. There are arguments for and against, but the idea was that we allow this reservation because states might be concerned about ISDS in the context of mediation. So this is, again, an example of flexibility. And just to also add, and it's also important, the reservations can be made at any time. This was something that is not the custom in the UN, but here it was. We understood it could be flexible. So there is maximum flexibility for states to decide whether they reserve at signing, ratification, or even after a few years down the road. The whole point is to get as many countries as possible. Thank you.
Thank you. Hector, do you want to address the question of the definition of commercial and what is a commercial settlement agreement?
Sure. With regards to the commercial nature of the settlement agreement, the convention does not provide a specific definition of what we mean by commercial. So my guess is that in practice it would be defined by the competent court, which is the explicit solution we find in the New York Convention. What we do find in the convention is specific exclusions of certain settlement agreements. For instance, a settlement agreement that is, I'm going to quote the convention here, in Article 1.2, it says that the convention does not apply to settlement agreements concluded to resolve that dispute arising from transactions engaged in by one of the parties, which is a consumer, for personal, family, or household purposes. So in theory, this provision would address the consumer-related disputes as an excluded area from the convention, and the other is relating to family, inheritance, or employment law. So if the settlement agreement is not dealing with these issues, then in principle, the settlement agreement would not be excluded. Whether it's commercial or not, that is probably up to the court enforcing the settlement agreement. And as opposed to what happens in the New York Convention, where the states have the option of making a reservation to apply the convention only to commercial disputes and not to civil disputes or other kind of disputes, we don't have that provision in the Singapore Convention.
Thank you very much. So now we will end with a note of hope. I am sure we will get a date when the EU member states will join the convention. Norel, the floor is yours.
Thank you. Thank you. As I explained in my intervention, our position initially was that this should lead to model law only, and indeed, part of the negotiation process, we were able to agree as a compromise that there would be both a convention and a model law. Now, of course, at this moment in time, we have also a convention. It was adopted last year in December. For us, the approach that the EU will take towards this convention is essentially linked to two elements: feasibility for us and timing. Feasibility means that we need a thorough assessment of whether this is feasible for the EU. We have started that assessment already in February, but this will have to continue in the future, and this is why I'm saying timing, because we'll have to involve stakeholders, the business world in this consultation. This in itself is a political decision, and as you know, now in Europe we are in a transition period. The new Commission will take office in November, so we'll continue that process, and we'll see. As you did mention, this is not the end of something, it's the beginning of something, and so this is the approach that we have to this particular question at this stage.
Thank you very much, Nari. It gives us hope anyway to have more states joining. So we are reaching the end of this panel, and we would like to thank you very much for your attention. I would like to thank first the government of Singapore and all the team in MINLAW who's been working very hard to make this signing ceremony and the conference a success, and also to thank my colleagues in Vienna in the UN Central Secretariat who could not be here with us today but worked very, very hard also for that. I would like to thank Nathalie Maurice Sharma, who has been a very elegant, efficient chair, and she displayed amazing leadership so that this project could be completed in a short period of time. And I would like to thank also all the delegations that have taken part to these negotiations. We have now in the mediation community, in the business community, and for all those who believe in the rule of law, we have a lot of work now ahead of us to promote mediation, make sure it works. And I have no doubt that if we all join efforts in 10 years from now, we will have a much better place to live in. So I would like also to thank all the members of this panel. Thank you very much, and thank you for your attention.
Thank you.
Great job.
And ladies and gentlemen, join me in thanking Corinne for moderating this session, please. Thank you. Thank you all.